Bom dia a todos, já iniciamos? Vamos lá então, é um prazer estar aqui com todos vocês hoje. Eu vou falar um pouquinho em português, depois eu já mudo para o inglês para fazer a introdução aqui dos trabalhos. É um prazer para o nosso escritório falarmos aqui nessa terceira edição da Arbitration Week de São Paulo. Então, teremos aqui speakers que têm um currículo excelente, que falam por si só. Vou passar para o inglês em prestígio aqui até dos nossos palestrantes internacionais e voltamos para o português em algumas das palestras. So it's a pleasure to be here with you today introducing the works of our seminar on the future of arbitration and mediation, part of the third edition of the São Paulo Arbitration Week, organized by CAMSA-CBC. It's an honor for me to be here opening our works because we have great speakers and I'm sure we'll have a great event. It's an honor for our firm, Trent Ross Watanabe, to be organizing and be part of the third edition of this arbitration week. So we thank CAMSA-CBC for the opportunity. We also thank a lot our speakers to join us today. So I'll briefly introduce you and have a very brief presentation of our speakers' resume. Of course, it's almost not necessary because their names are very known. They are very reputable, prestigious professionals that are here with us. So in a nutshell, we have Professor Kazuo Watanabe. And of course, you know that Professor Kazuo was a judge and a justice here in the state of São Paulo, in the appellate court of the state of São Paulo. He was partner of our firm he began as a partner in 1986 when he left the magistrate offices. He's a master and also a doctor in civil procedure law da Universidade de São Paulo. Então, acho que não preciso nem aqui ficar me alongando nas apresentações do professor Kazuo. É um prazer tê-lo conosco hoje. Professor, muito obrigada. We also have here, and of course, Professor Kazuo will talk about the future of mediation. We also have here George Lim. It's an honor, George, to have you here with us. Thank you very much. George is a very prestigious lawyer and mediator. Since the late 90s, he works with mediation in Singapore. He has been working with the mediation since then. So many years of experience. He helped to set up the Singapore Mediation Center in back in 97. So of course, this tells a lot about his great experience. He has been mediating many cases. He has been training lawyers and judges, teaching about mediation. So of course, he's very experienced, and he has a successful program where he sends the cases that start as arbitration to mediation, and only after that the cases go back to arbitration if necessary. And he will talk about this experience with us today. So it's a great pleasure, Professor George, to have you here with us. We also have Claudia Benavides. It's an honor to have you here, Claudia, with us. Claudia is a role model. I'm completely biased to talk about Claudia. I'm a huge fan of her. She knows that. Claudia is the head of our dispute resolution group of Baker McKenzie in Colombia. Claudia is also the head of the global dispute resolution group at Baker McKenzie. She's one of the heads of Baker McKenzie Diversity and Inclusion Committee. Claudia has a lot of experience in dispute resolution in all fields, mediation, arbitration, and of course, she is a model of female leadership, and she will talk about that with us this morning. So thank you very much, Claudia. We also have Laura Zimmerman. and Luis Borghi, who will talk about saving time and cost in arbitration. Laura Zimmerman is a very experienced dispute resolution lawyer in the US, in Baker McKenzie, New York office. She's a senior associate there with lots of experience also in the London office. And she has worked in banks as a secondee. And Laura participates very closely in activities related to the young boards of some of the most prestigious chambers and arbitral tribunals and so on. She's a member of the Global Advisory Board for ICDR Young and International. She also serves as an inaugural member of the AAA ICDR Innovation and Technology Advisory Council. So very, very experienced lawyer that will share with us experience today. And Luis Henrique Borghi is one of our partners in Trent Ross Watanabe Dispute Resolution Practice Group, one of my dear partners here, together with Joaquim Muniz. Luis has an LLM degree from UPenn, very experienced lawyer in the dispute resolution field, arbitration, mediation, and Luis is a mediation enthusiast. And we also have Joaquim Muniz as a moderator here today. Joaquim will moderate all the works, will ask questions. And Joaquim, of course, everybody knows about him. He's a very active lawyer in arbitration, mediation, all the ADR teams, and an enthusiast of mediation. Joaquim is a professor. Joaquim is present lots of events and seminars, and is also one of our very experienced partners in the dispute resolution team here in Trent Ross Watanabe. So it's an honor to be here with all of you. I thank you, our speakers, the organizers of this event, and also CAMS to CBC again. So thank you very much, Joaquim. You can start the works.
You
are on mute.
Obrigado, Juliano, falar em português para introduzir o professor Kazu. Uma honra estar nesse evento e é uma honra ter tantas conexões com tantos advogados de futuro, com uma visão de o que fazer com a mediação, com a arbitragem, para onde está indo, né? E já a Juliana não se apresentou, então vou ter a honra de apresentá-la, uma das nossas sócias de resolução de litígios da Trent Ross Watanabe, doutora pela Universidade de São Paulo, entusiasta de mediação, e uma das advogadas de futuro, de grande futuro e grande experiência que nós temos aqui. E nós temos no Trent Ross essa tradição de incentivar os métodos adequados de resolução de conflito, porque nós temos essa imensa honra de ter o professor Kazu Watanabe como um dos nossos name partners. Mais do que um sócio, ele é um modelo de advogado, de jurista e de pensador, né? Então, quando nós pensamos em fazer um evento para São Paulo Arbitration Week, a primeira coisa é ter a presença do Dr. Kazu, porque é o tipo de jurista único que nós temos no Brasil, que não só ele escreve sobre direito, fala sobre direito, ele pensa o direito de uma maneira muito ampla. E há muito tempo ele vem incentivando a mediação no Brasil. Se a gente for pensar aqui na resolução do CNJ 125, ele faz 10 anos, ele foi um dos principais entusiastas dessa resolução, e está por trás de todos os movimentos de incentivo da mediação no Brasil, e sempre pensando aí qual o próximo passo. Então, não podíamos deixar de ter o Dr. Kazu. Toda vez que eu participo de um evento do lado do Dr. Kazu, eu fico emocionado, porque realmente ele é um grande exemplo para nós, é o tipo de jurista que todos nós paramos para ouvir quando ele fala. Então, passo a palavra para ele, agradecendo o carinho de estar prestigiando o nosso evento, essa disponibilidade da coisa que se tem mais valiosa, que é o tempo, né? Dar o tempo para essa audiência.
Bom dia a todos. Inicialmente, agradeço as honrosas palavras do meu colega Dr. Joaquim Muniz. Ele sempre exagera as referências à minha pessoa. Eu espero que os senhores não acreditem muito no que ele disse, senão vão se decepcionar ao término da minha palestra. Mas, para mim, é uma honra muito grande poder participar desta live, trocando ideias com todos os senhores que têm experiência na área de mediação e arbitragem. Eu, particularmente, tenho me dedicado mais à mediação, não na prática da mediação propriamente dita, mas na tentativa de difundir, né, essa ideia da solução amigável dos conflitos, mais na área, talvez, acadêmica, na área mais de concepção de política pública, do que propriamente na atuação profissional. Então, eu gostaria de falar alguma coisa rapidamente sobre o futuro da mediação no Brasil. E, para tecer considerações a esse respeito, eu preciso ressaltar a relevância que a nossa Constituição Federal dá à solução pacífica dos conflitos. Mas, antes de falar do conteúdo dessa política instituída pela nossa Constituição, eu gostaria de traçar um quadro rapidamente sobre como está andando a mediação em nosso país. Lamentavelmente, há uma cultura entre nós que eu chamo de cultura da sentença. A cultura da solução contenciosa dos conflitos. E a conciliação e a mediação, isto é, as soluções amigáveis dos conflitos, tem sido vista como um meio menos nobre, né, de solução de controvérsias, ainda para uma maioria significativa de profissionais do direito. Entre eles eu incluo não somente advogados, como também juízes, promotores, procuradores, defensores públicos. Ainda vem a conciliação e a mediação como meios alternativos à solução sentencial, à solução adjudicada dos conflitos, como um meio de reduzir o estoque de processos que nós temos no nosso judiciário. Essa cultura da sentença, que ainda existe, tem muitas causas. E uma delas está no ensino jurídico que nós temos, que está mudando ultimamente, em razão, primeiro, da norma constitucional e também de políticas públicas que o judiciário tem adotado a partir de 2010, através da Resolução 125, já mencionada pelo doutor Joaquim Muniz. E também a própria Ordem dos Advogados tem procurado dar uma grande importância às soluções amigáveis. Mas, apesar disso, ainda continua a chamada cultura da sentença. Em algumas faculdades, como na Faculdade de Direito da Universidade de São Paulo, onde eu ainda continuo dando algumas aulas na área de pós-graduação, vem adotando disciplinas específicas para preparar os estudantes de direito para soluções amigáveis. Mas ainda nós vamos levar algum tempo, porque embora os jovens estudantes se entusiasmem, né, com a apresentação desses mecanismos consensuais, né, até eles se tornarem profissionais e começarem a mudar a mentalidade predominante, nós vamos levar algum tempo ainda, lamentavelmente. Um dos dados que eu gostaria de mencionar para mostrar esse estado de coisas, nós temos, eu já disse, a política pública estabelecida pelo Poder Judiciário em 2010, através da Resolução 125, né, pelo Conselho Nacional de Justiça. Isso já vai há 10 anos, nós estamos completando este ano 10 anos dessa política pública. Em 2015, há 5 anos atrás, foi promulgada a lei de mediação. Quer dizer, nós temos um marco regulatório da mediação. E também nesse ano, 2015, foi promulgado um novo Código de Processo Civil, que dá muita ênfase à importância das soluções amigáveis. Esses dois marcos já contam com 5 anos de existência. Mas os dados estatísticos que nós temos ainda são muito pobres, quer dizer, indicam um encaminhamento muito lento, né, dessa transformação da mentalidade. Por exemplo, em relação à mediação na área judicial, o índice de acordo de soluções amigáveis na estatística de 2019, publicado este ano, o percentual é da ordem de 20%. Falando em quantidade de processos, realmente talvez impressione aos senhores, né? Porque nós temos cerca de 70 milhões de processos em tramitação em nosso judiciário, né? Quer dizer, 20% solucionado por meios amigáveis é relativamente significativo, dá um número relativamente grande. Mas o crescimento é muito lento, e isso tem me causado um certo desalento, apesar da luta que a gente vem trabalhando. É muito difícil então, a mudança cultural de um país é extremamente difícil. Na área privada, por exemplo, eu faço parte da Câmara de Mediação e Arbitragem da Fiesp. E a quantidade de arbitragem é relativamente significativa, mas a mediação, lamentavelmente, é ainda muito, muito pobre. Por exemplo, nós tivemos Este ano, 2019, nós estamos em outubro, apenas 3 casos. Em 2018, que foi o ano que teve o maior número de mediações, nós tivemos 7 casos apenas. E assim, 2, 4, 6 cada ano. Está muito difícil de a gente crescer. E nós percebemos que teríamos que fazer muita campanha para mudar esse estado de coisas. E em 2014, seguindo o modelo da CPR, né, da instituição norte-americana sediada em Nova York, nós lançamos o Pacto de Mediação. Pacto mais no sentido de formar uma certa a cultura da solução amigável. O evento foi fantástico, houve participação de várias instituições, das faculdades, das várias universidades, várias entidades de classe, o próprio judiciário esteve presente, mas isso em 2014, né? Há 6 anos atrás, e, no entanto, o resultado ainda é muito pobre, como já lhes mencionei. E este ano, em razão da pandemia, que está afetando várias, na área empresarial, principalmente as micro e pequenas empresas, resolvemos lançar o projeto que nós denominamos de Pacto de Mediação Social. Estabelecemos um limite de R$100 mil para gratuidade, oferecer gratuitamente a mediação para as empresas até o limite de R$100 mil, isso durante um período limitado, que vai até o fim do ano, que nós pensamos que seria o período mais agudo da mediação, né? da pandemia, problemas causados pela pandemia, mas é possível que esse prazo seja prorrogado dependendo do que ocorrer em dezembro. Foi lançada há pouco menos de 30 dias, né? Mas a ideia básica que está atrás desse projeto de mediação social é de fazer com que os empresários sintam as virtudes da mediação, a real utilidade da mediação. Porque a percepção que nós tivemos é de que, quando as pessoas ouvem a respeito das vantagens da mediação, no plano intelectual, eles aceitam. Mas quando se trata de efetivamente solucionar o conflito, a tendência deles é procurar o advogado para judicializar, levar para o judiciário. Não entendem ainda a real utilidade, né? A eficácia da participação de um terceiro mediador ou conciliador capacitado, né, que possa ajudá-lo na solução do conflito. Então, a ideia foi essa, de fazer com que os empresários realmente sentissem, experimentassem a mediação, para se convencerem da utilidade, né, desse mecanismo. Mas, no entanto, até agora, cerca de 30 dias atrás, nós tivemos, por enquanto, apenas 3 pretendentes à solução mediada. Esse, vamos dizer, é o estado de coisas que existe no Brasil lamentavelmente. Existe arraigada na nossa sociedade a mentalidade que eu chamo de cultura da sentença, a cultura da solução contenciosa dos conflitos. Está difícil de quebrar essa cultura, de fazer a transformação dela. Mas, como iniciei a minha palestra dizendo da relevância constitucional, né, eu tenho procurado ressaltar isso para fazer face à mentalidade predominante que considera as soluções amigáveis como a forma mais primitiva, menos nobre de solução dos conflitos de interesse. Mas a nossa Constituição, que é de 1988, diz expressamente no preâmbulo, quer dizer, na introdução, que o Estado democrático brasileiro, destinado a assegurar o exercício dos direitos sociais e individuais, a liberdade, a segurança, o bem-estar, o desenvolvimento, a igualdade e a justiça como valores supremos de uma sociedade fraterna, pluralista e sem preconceitos. E aqui vem o ponto que nos interessa: fundada na harmonia social, comprometida na ordem interna e internacional com a solução pacífica dos conflitos. E traz, em outras passagens, a menção à conciliação, à mediação, à solução amigável dos conflitos. Por exemplo, quando cuida da organização judiciária, determinando a criação dos chamados juizados especiais cíveis e criminais. E também, entre os valores fundamentais, né, menciona a cidadania, a dignidade da pessoa humana. E quando fala dos objetivos, né, dos fundamentais da nossa República Federativa, diz que um dos objetivos seria construir uma sociedade justa, livre e solidária. E não há como construir uma sociedade solidária, né, fazendo com que todos os conflitos sejam solucionados de modo contencioso, né? A solução amigável do conflito está à base desses objetivos estabelecidos na nossa Constituição. Em razão disso, é que nós temos procurado fazer com que empresários e pessoas físicas também se convençam de que esses mecanismos consensuais são importantes não somente no plano individual, como no plano também social. Mas, como já disse, está num caminhar muito lento. Se bem que a gente percebe que há um crescimento, embora lento, né, de soluções mediadas, soluções amigáveis. Mas, talvez por causa mais da minha idade, a gente, à medida que envelhece, vai ficando mais impaciente. Eu vejo que esses números estão num crescimento lento demais. Enfim, a nossa luta em relação à mediação, o futuro da mediação, eu tenho certeza de que seguramente nós vamos ter um grande crescimento ao longo do tempo. Mas O problema é quanto tempo nós vamos levar para alcançar essa solução. Agora, só para terminar, eu gostaria de relatar um fato que me dá uma certa esperança. Em 1985, logo após a aprovação da lei do juizado de pequenas causas, no estado de São Paulo, se iniciou a implementação desse novo modelo de justiça através da instituição apenas da solução amigável. Nós chamamos de juizado de conciliação, juizado informal de conciliação. Tomamos um modelo japonês, né, de juizado de conciliação, e o resultado foi fantástico. A população aceitou plenamente e houve uma grande participação. O índice de acordo nesse juizado de conciliação foi superior a quase 90%, ou mais de 90% de acordos. Então, a gente percebe que, desde que se organize bem, adequadamente, a resolução de conflito, e desde que esteja presente o Estado, de alguma forma, para dar apoio a essas instituições, o povo, em geral, aceita a solução amigável. Mas, quando se passa para o plano da solução para os grandes conflitos, ou para conflitos médios, né, está difícil de conseguir criar essa mentalidade de solução amigável de conflitos. Em linhas gerais, doutor Joaquim, são essas as considerações que queria apresentar aos colegas do painel, né? E gostaria, então, de ouvir as colocações dos demais colegas. Muito obrigado pela atenção.
Nós que agradecemos, doutor Cazu, pelos seus comentários, pela sua humildade. Fazendo um cálculo aqui, com os 20% de taxa de acordo nos últimos anos, desde a utilização maior da mediação, incentivado muito pelo trabalho do senhor, a gente teve mais de 14 milhões de processos extintos por acordo, o que dá uma quantidade maior de processos do que de todos os processos em países grandes, como Espanha. Então, a gente acabou com uma Espanha de processos, graças a esse acordo, numa mediação que ainda está se desenvolvendo. Imagine quando efetivamente houver o tipping point. E o professor terminou muito bem falando da dificuldade cultural, da necessidade de incentivar. And switch to English, because that's exactly, George, Professor Cazu was telling the relative success of mediation of Brazil. We managed to settle more than 10 million judicial lawsuits through mediation, but the problem is they still have 80 million to go. So it's the glass is half full but half empty. And there are a lot of ways to try to foster mediation. And today, there are a lot of discussions on law and economics. And if you get to Richard Thaler, that won the Nobel Prize 3-4 years ago, talk about the nudge, the way that entities could give incentives for the parties to do the right thing. And mediation is a very positive procedure, and we should find ways for the institutions to foster mediation. And I invited you first because I'm a big fan of your work at the Singapore Mediation International Center, and second, implemented there a very interesting protocol that's really fostering mediation. So I pass the floor to you so that you could speak a little bit about your institution and share this very interesting experience that could be replicated in, for instance, in Brazilian institutions.
Joaquim, é só se permitir, só para... Quando eu falei em 20%, quer dizer, nesse cálculo foram excluídas alguns processos, por exemplo, execuções fiscais. Então, execuções fiscais representam metade do acervo nosso. Então, em números, a quantidade de acordos foi da ordem de total de 3.900.000 processos, quase 4 milhões de processos. 20% daquele universo considerado. E uma outra coisa que, no judiciário, existe a norma que a primeira audiência é obrigatória e tentativa de solução amigável. Quer dizer, existem algumas estratégias que forçam um pouquinho esse resultado, quer dizer, para alcançar esse resultado. Então, é apenas para não ficar com a impressão de que é 20% de total de 70 milhões.
No, that's interesting. Like Professor Caso was correcting that it's like, since you have like tax claims that you cannot settle, and tax claims are more than 50% of the lawsuits, the actual number is 4 million lawsuits settled per year, right? Por ano, né? 4 milhões por ano. Que per se, it's a very high number, but you could do better because you have like from 70 to 80 million lawsuits ongoing. So George, if you could share a little bit your experience in the Singapore Mediation International Center.
All right. Good morning, everyone. And thank you, Joachim, and your organizers for inviting me to this webinar. It is a great privilege for me. You know, Singapore is far away from Brazil, but you don't realize this, but actually Brazil has a large influence in many parts of the world, including Singapore. You know, when I was a young boy, we watched soccer, Brazilian soccer, and Pelé was like a soccer god for us, okay? And now my son watches Neymar, Alisson, Fabinho. So you have a big influence on us in the form of your samba soccer. But not only that, I've been listening to bossa nova music, and of course your Brazilian coffee, you know, great. So you may not realize this, but you actually have an influence over people in many countries, including Singapore. So I was asked to come here to share the Singapore perspective, or perhaps the Asian perspective on your theme, which is very simple, but which is very apt and important, the future of arbitration and mediation. So I would like to share today, you know, some of the trends which will affect our future, particularly post-COVID, post-COVID-19. And I would like to start with talking about the increased use of hybrid dispute resolution processes. People are using a combination of arbitration and mediation processes. I will share with you what Joachim referred to, which is the Singapore, the ARB-MEDAP protocol. It's arbitration, mediation, arbitration, a protocol which we have with the Singapore International Arbitration Center, SIAC, which some of you are aware of. And touch on enforceability, which is becoming a very important thing in mediation with the Singapore Convention on Mediation, and a little bit on online mediation, okay? All in the space of 15 to 20 minutes. So if you will just bear with me, I'm just going to share some slides so that we can move along faster. Okay, can you see my slides? Can you just indicate? Good, okay. So yeah, I'm just going to start with showing you a survey from the Queen Mary University, and this is 2018, on the increasing use of hybrid dispute resolution processes, okay? So just bear with me, but look at the chart. This was a survey on, and they asked arbitrators, lawyers, and in-house counsel, what was their preferred method of resolving cross-border disputes. And so we're focusing on international disputes. And if you look at the center group of well, I call it pillars, okay? The blue pillar represents the lawyers, the private practitioners, okay? The light gray represents the arbitrators, and the black pillar represents in-house counsel. Okay, you got that? Okay, so when they asked the participants, okay, what was your preferred method of resolving cross-border disputes? And when we talked about international arbitration, the private practitioners, the lawyers said, you know, the blue column, yes, 51% said arbitration. And then the arbitrators, of course, you know, 54% of the arbitrators said, you know, international arbitration. But when they asked the in-house counsel, okay, who represent the companies, it was 32%. So you see the difference, all right? And then if you move to the left-hand side, okay, of this survey chart, when they ask people about their views on international arbitration combined with ADR mechanisms, it mainly mediation, arbitration and mediation. You look at the blue column, the lawyers said 46% said, you know, that's what they preferred, and the arbitrators 43%, but the in-house counsel people said 60%. So this is evidence on the ground that there is a preference now, and it makes sense, all right, because it's not one particular dispute resolution process. People are combining arbitration, mediation, and this has been the trend worldwide. Okay, and you can see this happening also with the growth of mediation, as well as you are seeing leading arbitration centers now offering mediation services. It's not just arbitration alone. I mean, in Brazil, I know, I mean, I don't know all the situation, but CBMA does arbitration mediation. In the US, Dr. Kazuo talked about AAA ICDR, they do arbitration mediation, JAMS does that. And in our part of the world, you know, in Japan, you used just to have the Japan Arbitration Association. Now it's got the Japan International Mediation Center, and Korea as well, and many parts of the world. So you see this happening all over the world. Okay, so that is one thought I want to leave with you. It's no more arbitration or mediation or arbitration versus mediation, but a combination. What fits? What is best for the parties? What is best for the clients? Okay, and for us in Singapore, we saw this coming, and 5 years ago, before the Singapore Convention, all right, we had this protocol with the SIAC. Okay, so my organization, I chair the SIMC, which stands for the Singapore International Mediation Center. We are a young body, 5 years old, not for profit, focused on promoting the mediation of cross-border disputes. Okay, it's just a very young body. And we are a sister company of SIAC, the Singapore International Arbitration Center, which I think some of you know. So we started this protocol 5 years ago, and we call this is a one-stop process, okay? People who are concerned about enforceability will come to us. They will register their dispute as an arbitration first with the SIAC. So the initial papers are filed, a tribunal is formed, and then the arbitration is stayed. Okay, it's adjourned for 8 weeks, just 8 weeks, so that people cannot use this as a delaying tactic. The file is then transferred to the Singapore International Mediation Center, my organization, SIMC, where we will appoint a mediator, different person from the arbitration tribunal, and the mediation takes place within that 8-week period, okay? And if the matter is settled, then the settlement agreement, okay, the parties go back to SIAC, and the settlement agreement is then converted into an arbitral award, which you know will be enforceable around the world under the New York Convention in close to 160 countries. Okay, so that is the protocol we have with SIAC. And if the dispute is not settled at mediation, then it carries on. It goes back to the SIAC, and it goes on with the tribunal with arbitration. So either way, the parties get an outcome, they get a result. But what is good about this process is that parties get a chance to arbitrate as well as mediate. They get a chance to try and settle the matter halfway through, okay? And within a process which doesn't delay things. 8 weeks, an 8-week gap. And we found this to be very popular. In fact, I'll just show you some statistics. Just for the last 4 to 5 years, SIMC, we've done 130 cases, total dispute value about 3 billion, settlement rate of 70 to 80%. And our ARP-MEDUP statistics, okay, about close to 20% of our cases are AMA or ARP-MEDUP cases, with a settlement rate of 75 to 80%. Okay, so we found that on the ground, this is already happening, and people are very interested. And this is something which Brazilians might want to be, you might want to explore, because you will find that it has gained traction in Singapore, in Asia, in many parts of the world. It might be useful for you. So that's just another thought for you. Okay, another combination is this. All right, you see all of us wearing masks. Okay, so this was not too long ago. This is a MEDUP service which Singapore, SIMC, in June, I signed a memorandum of understanding with the Shenzhen Court of International Arbitration. So a mediation center and an arbitration center in China, and our settlement agreements, okay, are now, they will recognize them, and they will help us enforce our settlement agreements in China. So that is another variation of cooperation between the arbitration and the mediation institution. And all this goes to the issue of enforceability, okay? And you know why, right? Because for cross-border disputes, enforceability is such an important issue. Okay? And which brings me to my other point, my next point, which is about the Singapore Convention on Mediation. So some of you may have heard of this, but in 2014, UNCITRAL, which is the United Nations body which promotes international trade, they started a working group to look into the possibility of having a convention which enforces international mediated settlements. So again, the easiest way is, this is the equivalent of the New York Convention for arbitration. So if I have a mediated settlement here, and if Brazil is a signatory, can I go to Brazil and enforce it without having to start new proceedings? So that convention, I was part of the deliberations at the United Nations for 4 years, from 2014 to 2018. And it was such a good experience. And we came up with a document, and Singapore chaired that working group of 50 countries. And we were asked to host the signing ceremony, which was held last year in Singapore on the 7th of August, 2019. And you know what? 46 countries signed the convention on the first day, okay? Today there are 53 countries, but on the first day, 46 countries. And if you had asked me at the United Nations how many countries would sign, if you told me 10, I would say, great. But we had 46 countries. And so that is significant to me because it shows that mediation, okay, there is a need for mediation. There is an interest and a need for mediation. And that's why 46 countries signed it, okay? Of the 46 countries, the US, China, who are your important trading partners, right? US, China, and India signed. And to me, that is also significant because it's more than half of the world's population. I was in another webinar with Joachim, and I was telling Joachim and the others that, look, Brazil has to sign this, okay? Because this is big. This is really good for international trade. And for those of you who are arbitrators, can you imagine having arbitration without the New York Convention? Right. So now we've got this for mediation, and to me, this is another option which we should offer to business people. Since you already have arbitration, they want to try mediation, and they can enforce international mediated settlements easily. This will facilitate trade and growth. The convention has come into effect. We have now got 6 ratifications, and it came to effect on the 12th of September this year. Okay, just last month. So watch out for this space, because I think more and more countries will sign. And as I said, my wish is that Brazil will also sign very soon. Okay, so this is a chart showing the countries we have signed, yeah, and the major economies. I want to move on with this, but maybe interesting for you to look at Latin America and Caribbean, right? You see that. So apart from the US, which is in North America, we've got Chile, Colombia, Ecuador, Grenada, Haiti, Honduras, Jamaica, Paraguay, Uruguay, Venezuela. Okay, so maybe the next time when we meet Joachim, I'll see Brazil there as well. Yeah. Okay, so let me move on to something else, which is really online mediation. Okay, I'm just touching on some of the trends because this is the future. And for us in Singapore, we have been doing a lot of online mediations, and I think arbitrations as well. And sometimes it's a mix. Sometimes there are people who are physically there and some people on Zoom or on webinar or on WebEx, okay? And this photograph was taken at the Maxwell Chambers in Singapore. It's a mediation conducted by the Singapore International Mediation Center. It's taken by permission. These are only the lawyers, okay, not the parties. And so we've preserved confidentiality. But you see how this has worked, right? And I'm not sure whether this is happening in Brazil, but this is another trend all over the world. And you know, online mediation is more difficult, really, because you don't have the advantage of face-to-face meetings, persuading people. But there are also advantages because it's become cheaper now. You know, it's become so much easier, and like parties who would say, no, I'm not going to go through a mediation because it's just going to waste money. They might now try it because it's so easy and it's really quite cheap. You don't have to fly people in, you don't have to pay for so many things, and they can do it from the comfort of their offices or their homes. And so we found that actually there is an increasing usage of online mediation, and there, for the mediators, there are different skills which you have to pick up. Okay, so for example, probably you have to do more private confidential meetings to build rapport, as opposed to a big session on the internet. So this is something which I think in the future, post-COVID, this will still happen. And for people in court or in arbitrations, as I said, it's so much easier to persuade them to do mediation. All right, I want to keep to my time. So just one final point, okay, which is really, for me, sums up the future of arbitration and mediation. It is what I say, it's not a zero-sum game, okay? You know, for us, as many of you, I think, are lawyers, for us as lawyers, we like to think of ourselves as litigators or arbitrators or mediators, right? But I will tell you from experience, for clients, for the parties, all right, all they want is someone to help them solve their problem. Okay, so that they can move on with their business, they can do something else. They don't want to be caught up in long drawn out battles or fine points of law. And to me, the future is this. Clients are looking for problem solvers. So I have a son who's a lawyer, and young lawyers ask me, what's the future? And I tell them this, that, you know, the future for you is to equip yourselves with different skills so that you can offer different services to clients, okay? Because clients may need you to be a court lawyer, may need you to go to arbitration, may need you to represent them in a mediation. You have to be able to offer those different skills. So I tell young lawyers, arbitrators, mediators, pick up your skills, okay? And tell parties, look, you are able to represent them effectively and help them solve their problem as quickly as possible in the best way possible. So for me, that is the future. And on that note, I just want to thank you for having me here, and I'll be happy to take questions. Okay, thank you very much.
Thank you, George. And there's about the Singapore Convention that's very important because you allow enforceability of settlements done through mediation. There is a favorable opinion from the Ministry of International Relations. So I hope Brazil signs, at least that's a positive indication from the government. Now I pass the floor to Claudia Benavides, Head of Litigation in Baker McKenzie. And the fact that Claudia is having such a high position, being a female partner and coming from Colombia, shows how things have changed in the world of arbitration, mediation in the last years. I remember when it starts discussing about pledge, more women participation, and that's something that thankfully it's really becoming a reality. You see more gender diversity, more nationality diversity, and Claudia has a strong presence and a lot of work on those points. So I want to hear her telling her story and how can improve our pool of practitioners, arbitrators, mediators, because it really equals to improving the quality of the service rendered.
Well, thank you so much, Joaquim. Thank you very much to my French Rosie Watanabe colleagues for this very kind invitation to participate in this very interesting webinar in the context of the Sao Paulo Arbitration Week. It is certainly an honor for me to be here. I have to say, though, that I would have loved to be there in person, meeting and sharing with so many dear friends and colleagues in Brazil. But then on the other hand, I'm thankful to technology for allowing me to join you through this webinar today. And I would also like to thank Juliana for her very kind words while introducing me, and would like to say that I am Juliana's great fan. I've known Juliana for many years now, and I can say that she's an absolutely amazing lawyer and colleague, the same way like Joaquim, with whom I've worked for so many years. So I will present now a few comments on gender diversity. And to do so, I would like to divide the presentation in basically two main sections. First, some remarks regarding gender diversity in the legal profession in general. And then second, share with you some comments on gender diversity within the international arbitration community specifically. So talking about gender equality in the legal sector in general, what is the current state of gender equality in the legal profession? As probably you all know, a very significant number of female practitioners nowadays are graduating each year from law school. About 50% or more of those that study law are women. And this trend applies to many jurisdictions across the globe. So this trend is, of course, reflected in the number of women that, the lawyer women that start their careers as young associates in law firms. Also about or around 50%, and sometimes even more, of the young lawyers hired by law firms are women. And data shows, based on what I've just mentioned, that generally speaking, there are no entry barriers to the legal profession for women, generally speaking. However, where we see issues in terms of the legal profession, where the participation of female lawyers tend to decrease, is basically during the course of their career path, strongly declining when it comes to female partners, and even more so if we're talking about equity partners, if we look at statistics around the globe, generally in law firms. So in terms of percentages, generally speaking, and of course, these may vary depending on countries and depending on law firms, but generally speaking, around 20 to 25% of partners in law firms are women. And about the same percentage applies when it comes to leadership roles within law firms. So despite the fact that at entry level, we have around 50% female lawyers, when it comes to partnership, the number decreases importantly. For instance, in 2019, the American Bar Association published data that showed that despite the fact that almost half of associates in law firms are women, less than a third are partners and less than 20% are equity partners. Interestingly, for Latin America is a report that was produced by Chambers and Partners recently into 2020. You know that Chambers and Partners is a legal directory that researches perception of law firms and practitioners in the legal market. And they recently published their results for individual rankings for Latin America. And in that report, or in those rankings, what they do is that they recognize practitioners in multiple areas for many different law firms across the region. And they decided to produce in that report an analysis in terms of gender diversity when it comes to these individual rankings. And the results, it's worth to take a quick look at them. In the individual rankings for Latin America, only 19% of the ranked practitioners were women. That means that 81% of the individual rankings were for men in Latin America. There are some numbers that are particularly striking. For instance, in Mexico, only 9% of those individual rankings are for women. And in Chile, 12% of those individual rankings were for women, and followed by Argentina with 13%. So the above numbers, I believe, further confirm the trend that I've just mentioned, because it shows that when it comes to who are those that are recognized in the market as leading individuals, at least what is shown by this particular directory, shows that those that are recognized are mostly our male colleagues, and in much lesser numbers, our female colleagues. So to achieve greater diversity in the legal profession, it is really fundamental to identify those factors that act as barriers for career development of female within the legal profession, to address those factors that have that negative impact and that reduce especially the retention rate in senior positions. That's where we are facing issues in retention in senior positions. So, and a quick example, just in Colombia, where I'm based, research that was done back in 2019 showed that, for instance, in the major law firms based in Colombia, only 15% of the managing partners of those firms were female. That shows, again, the trend in terms of the participation of women in leadership roles in the legal profession. Just very quickly, and to share with all of you some of the things that we've done internally at Baker McKenzie at a global level to try to address this particular issue, and that may be useful to consider as potential tools to be used in this respect. For us, for Baker McKenzie, diversity and inclusion in general, in all its dimensions, is strategic. It is very fundamental. It is part of our core strategy for many reasons. And therefore, we've implemented actions to address issues that relate to diversity and inclusion. And then particularly, we've implemented actions with respect to or to address gender diversity, because gender diversity has been strategic in our firm for several years now. And this is not only because we consider this is what things should be, we should have gender equality within our firm, but also because, as we've just shown, in terms of our the lawyers that we have, our pipeline, our talent is composed by female in a very important percentage. So it is also considering that the strategic to make sure that we get women also to partnership and to leadership positions. So we've implemented, and I'm going to mention this very quickly, as I said, by way of examples of tools that could be used in this respect. One is what we've called the GATS, or the Gender Aspirational Targets. What we've done here is that we've established some measurable targets that we've committed with. And those targets are that by July 1st, 2025, we want to have at least 40% of our partners women, 40% of our partners male, and 20% would be non-binary. And by establishing this temporary measure, what we want to do and our objective is to accelerate the pace of progression towards gender equality in partnership positions. And not only in partnership positions, but also in leadership positions. So this 40-40-20 is also something that we want to see by July 1st, 2025. That's our goal. We know it's challenging, but that's also a target that we want to achieve in terms of leadership positions within our firm. We were actually the first global law firm to establish these ambitious goals for 2025. And actually, just to provide a number in terms of how our gender diversity is within the firm, in Latin America in particular, we do have a good representations in terms of female representation among partners. Actually, 36% currently in Latin America of our partners are women. I understand that for French Rosy Watanabe, the number is even higher. It's over 50% in terms of participation of female lawyers in the partnership. But then when it comes to equity partners, our numbers are, globally speaking, lower than that. And that's why these targets that we've established are challenging. We have currently at a global level in terms of equity partners, 20% of them are women. So, so we do have a lot to do in this area still. We've progressed a lot. We think that these tools that we've implemented have served the purpose, but there is still work to do. Another quick program that I would like to mention is one we call LIFT. It's Leaders Investing for Tomorrow. And it's a 12-month program that is based around sponsorship. So very well experienced and established partners within Baker McKenzie sponsor high performer females in the progression of their career to become equity partners and to serve in leadership positions. And the program involves different sorts of actions that are taken to make sure that we are providing our high performers, our female high performers with tools and mechanisms to progress in their career to leadership positions and to partnership. And then finally, a third program that we also believe that has an impact in terms of gender equality is a program that we call Be Agile. And although we've established this program for several years now, it seems a little bit as if it was related to what is happening nowadays with the pandemic, because one of the core elements of our program called Be Agile is remote work, or allowing agreements between our people. And this applies not only to our female practitioners, but to everyone within our office, to every lawyer within our office, but has a special impact, I would say, when we're talking about gender diversity of working remotely. That, as I said, sounds a little bit, when we're talking about this in the context of the pandemic, one would say, well, but nowadays everyone is working remotely. But before the pandemic, that was not the case. And we thought that was an important part of this Be Agile program, as well as flexible hours and part-time. And we believe that by having those tools, we are in a better position to increase retention of our female talent in their progression of their careers. So that to mention just briefly those three tools. I would like to talk about now gender equality in international arbitration, more specifically as a subsector of the legal practice. So with respect to gender equality in arbitration, I would like to refer first to the current state of gender equality in this practice area. And then I would like to refer to certain initiatives and actions that the international arbitration community in general has implemented. So, and then of course, those actions and initiatives were implemented to achieve greater gender equality. So in terms of the current state of gender equality in arbitration, first I would like to say, and I think this is something that we share among practitioners within the arbitration community. And it's the fact that for the international arbitration system as a whole, achieving gender equality is fundamental because it has an impact in the legitimacy of the system itself. And also it has a huge impact in the confidence that users may have in the arbitral process. So there are many other reasons as well why we believe that achieving gender equality in the international arbitration practice is fundamental, but these two, I would say, are key. To talk about the current trends in terms of gender equality in international arbitration, I would like to refer to the extraordinary work that was done by the Cross-Institutional Task Force on Gender Diversity in Arbitral Appointments and Proceedings that was issued this year, 2020, because it is a very thorough report on the matter. What the task force did was they compiled the actual statistics related to this topic and conducted a very thorough analysis of the current state of gender diversity and discrimination in international arbitration. This task force included major international arbitral institutions and organizations, including ICA, the International Council for Commercial Arbitration, the IBA, ICC, HKIAC, LCIA, ICSID, ICDR, ABA, Arbitral Women, well, among others. And also law firms such as White and Case and Three Crowns contributed importantly to this effort. And then, according to this report, progress has been in fact made in terms of representation and inclusion of women within the international arbitration community. But of course, the report also acknowledges that there is still a long way to go to achieve gender equality. So to this end, I invite you to take a look at that report because it also provides specific actions and suggestions to advise on gender equality, both in the composition of arbitral tribunals on the one hand, but then also more broadly to advance on gender equality among the participants of the arbitral process in general. So I think it is interesting to take a quick look at the information provided by this report. In terms of the overall trends, the report provides information that I think that sets the scene for future discussion. Since 2015, the proportion of female arbitrators has almost doubled from around 12% in 2015 to 21% in 2019. And this result is provided, is based on the information that was provided by major international arbitration institutions. Interestingly to note that the report also shows that the pace of change has accelerated over the last 10 years. So for example, the report shows that 1990 data from the ICC on the percentage of female arbitrators appointed to international arbitration tribunals show 1%. In 2010, that is 20 years later, that number arose to 7.2%. And then as of 2018, the ICC data show that 18.4% of all tribunal appointees are female. So the report basically shows that historical data from other institutions show a similar trend, and the increase in the number of cases is not the only explanation for the increase in female arbitrators, which is because that was also an important analysis that they had to make, whether the increase in female arbitrators was related to the increase in the number of cases, and what they realized is that they were not directly related. Interesting to see among the different participants, who are the ones actually appointing more females. So in terms of institutional appointments, the report concludes that institutional commitments to diversify arbitral tribunals have consistently translated into positive and tangible results. So over the past 5 years, approximately 1/3 of all institutional appointments have been female. This information, of course, presents variations during the 5-year period that the research looked at. And it depends also as well on the particular institution that you look at. But just by way of example, according to the report in 2015, 5.9% of all ICSID appointees were female, whereas in 2019, that percentage number increased to 25.8%, which is very significant. For the ICC, the percentage of female appointees increased from 19.6% in 2015 to 34% in 2019. And then similarly and importantly, I would say, for LCIA, the percentage of female appointees increased from 28.2% already in 2015 to an impressive 48% in 2019. So in round numbers, for example, for LCIA, there were 55 women appointed in 2015, and that number arose to 105 women appointed in 2019. So that's interesting, and the impact that institutions have had in the appointment of women in arbitral tribunals seems to be therefore very significant and very relevant. In terms of co-arbitrator appointments, which is another source of appointments of female candidates, the report says that those appointments doubled since 2015, according to available data. So the women as a percentage of co-arbitrator appointments was 9.6 overall, based on the information provided by the institutions that participated, that were able to provide this information, and the information available to the task force was 9.6% in 2015, compared to 21.5% in 2019. So overall, there has been an increase in the proportion of female co-arbitrators appointees in this period of time. However, the report also says that given the significant variability of data over the years and the small sample sizes for many institutions, in this particular area, the overall trend should be treated with some caution. And then in terms of party appointments, which is also a relevant aspect to look at, the report concludes that data available shows that a relatively small portion of party appointments between 2015 and 2019 were female. The report says that on average, across institutions, there has been a slow increase in party appointments over the last 5 years, from 8.5% in 2015 to 13.9% in 2019. So the report acknowledges also that the ICC has seen a steady increase in the proportion of female party appointees, which I think is relevant and worth to mention, from 6.9% in 2015 to 15.3% in 2019. But several other institutions have seen staggered changes in the appointment of female arbitrators by parties. The information that the task force received with respect to whether the appointments were made by claimants or respondents is not, that they don't have sufficient data to get a conclusion there. So there are no particular comments with respect to appointments made by one party or the other. So when the report makes a comparison with respect to the trends of female appointments by institutions, parties, and co-arbitrators. They do that comparing those appointments in year 2016 with the appointments that were made in 2019, and concludes that in general, institutions appoint a greater proportion of female arbitrators than parties and co-arbitrators, as we've just seen. So the overall trend suggests, and then based according to the information in the report, that the greatest room for improving the diversity of arbitration appointees may lie with parties and co-arbitrators. And then it is important to acknowledge that, because then action needs to be taken by these parties. So I think it's worth to notice what steps have been taken to achieve greater gender equality in arbitration. And several of these actions and initiatives had actually played a role in the change that we've seen taken place between 2015 and 2019, which is the period of time that the task force reviewed, essentially. But within these steps that have been taken, I would like to mention one in particular. There had been many different initiatives and many things that had been done across the globe, focused on increasing female participation in arbitration, particularly as arbitrators in arbitral tribunals. But I would like to mention one in particular that I think that has been very strong, and that also summarizes many of the actions that one needs to take into account if we want to increase gender diversity and if we want to reach gender equality. And this is a very important initiative. It's the ERA Pledge, the Equal Representation in Arbitration Pledge. This initiative, as many of you probably know, was born back in 2015, when members of the arbitration community, both men and women, drew up a pledge to take action in recognition of the underrepresentation of women on international arbitration tribunals. And the objective of the pledge was and is to increase on an equal opportunity basis the number of women appointed as arbitrators, with the aim of achieving gender equality on this front. At October 2020, this pledge had around 4,380 signatories. And this number includes both individual signatories signing on their own name, as well as multiple organizations. Among the signatories, there are, of course, law firms, but there are also arbitral institutions, as well as corporations who would be the end users of arbitration. And I would like to mention, so this initiative has 10 pledge resolutions. There are 10 pledge resolutions. And I would like to mention just some of them that I believe are particularly relevant for all of us to take into account in this journey towards gender equality in international arbitration. And first, it's, of course, to always keep in mind when you're appointing arbitrators that one should consider appointing women as arbitrators on an equal opportunity basis. That is fundamental. Then also to ask arbitral institutions whether they have a policy in place for tracking the number of female arbitrators they appoint. Because what we've seen is that sometimes arbitrations or organizations may commit, but the important part of making that commitment is that you actually track the number of appointments, of female arbitrators appointments. It is really key to do that tracking, because that's what allow measurement of improvement in this area. Then another resolution within this template resolutions that were established in this initiative is that when putting together a list of proposed arbitrators, you can make use of the pledged female arbitrator search tool. If you actually go to the ERA Pledge website, you'll see that there is a search tool to identify potential female candidates for arbitrators. And that is a very useful tool if you don't have in the top of your mind potential candidates for arbitrators when you are considering the composition of the arbitral tribunal. Then it is a good tool and a good way to identify names and profiles that would be what you require as arbitrators in a specific case. Then also suggesting a woman for speaking a slot in an arbitration conference, considering offering co-authorship to a female arbitration practitioner for your next article or opinion piece, acting as a mentor to a junior female colleague within the arbitration community, and bringing a male colleague to the next event on women in arbitration. These are not all the 10 pledge resolutions, but just a few that I would like to mention. And with respect to this last one, where it says bringing a male colleague to the next event on women in arbitration, I strongly emphasize the importance of considering this not a topic that is relevant for women only. It is a topic that is relevant for our community as a whole, and we work together hand in hand with our male colleagues in achieving gender diversity. Gender diversity brings benefits for us all, as a community, as practitioners, as family members. So this is something that unites us towards achieving a goal that brings benefits to the community entirely. And very briefly, some of the things that we've done internally at Baker McKenzie that are addressed specifically to gender equality within international arbitration, or that have an impact in our international arbitration practitioners. First, I've just mentioned the ERA Pledge, and Baker McKenzie is of course a signatory of this pledge. But some additional measures that we've taken internally and that are focused on arbitration practitioners specifically. First, we've created a Women in Arbitration group. That's how we call it, and it serves various purposes. On the one hand, it allows all our women arbitration practitioners to get to know each other across the globe. We have many offices in many different places, and it is a very good way to strengthen our women network. It also serves as a discussion forum for arbitration topics, and those could be legal, about soft skills, but also for discussion of career development issues. It is also a forum that serves for profile raising, for training. We invite members of the international arbitration community in general, and the broader international arbitration community, to speak in the forum. Actually, I have to say that Laura Zimmerman, who is one of our panelists today, and a very well experienced practitioner in the international arbitration field, based in New York, is a very active member of our Women in Arbitration group. We are very thankful, Laura, for all of her contributions.
Hey, Claudia, it's time to pass the floor to Laura, so that she could speak.
Yes, it is. I'm just wrapping up. I have 1 more minute wrapping up, and we'll go to. So then just to summarize, or to mention the other 2 programs, the mentoring program is specifically designed for female international arbitration practitioners, and our role model program. Finally, I would like to make a last remark. Situations like the one that we are now currently experiencing with the pandemic tend to have a stronger negative impact on minorities or underrepresented groups. So it is critical, and I would like to emphasize this, it is critical that we keep an eye on gender diversity in this period of time, that we keep an eye on our targets, policies, and goals, that we closely monitor gender diversity in these difficult times, making sure that we won't lose progress made so far, and that we keep having gender diversity as a priority. So thank you so much. Joachim, over to you.
Thank you. It's a pleasure to have you here, Steve. We are very proud of Baker McKenzie and very proud of Tente Rossi. Here in the last 10 years, we had more women in management role, including our management committee, than men. So that's a reality that we are bringing our female parts to where they deserve, to high management positions and to leadership. And we have the pleasure to have a future leader here, Laura Zimmerman, who speak with Luis Borg about the main concerns that our clients have, how to tackle time and costs in international arbitration. Laura will specifically say some words about the use of technology. So, Laura, the floor is yours.
Yeah. So just before Laura starts talking, Joaquin, let me ask, as the last speakers, how many minutes we have? So
20 in total for both of you.
Oh, okay, thank you. So good morning to everyone. So Laura and I will be talking about saving time and costs in arbitration. We will try to be as much interactive as possible. So also feel free to jump in and send your questions through the Q&A that we have in Zoom. So we will basically cover our presentation in two major topics. So the first topic will be recovery and types of costs in international arbitration. And then we will talk about the mechanism to control time and costs. We'll talk about arbitrator selection. We'll talk about bifurcation and partial awards. We'll talk about limitation of discovery, the effective use of technology. And if we still get the time, we will also talk about the first procedural conference. So why talk about saving time and cost in arbitration? This actually has been a really hot topic for a while, as the legal costs incurred by the parties in international arbitrations continue to rise. It became really important for the parties to assess cost benefit and risk involved in opting for arbitration. And also, once the arbitration is commenced, to control such costs. So we are very used to have clients asking how much an arbitration proceeding will cost. Most of them believe that costs are too high, and also that nowadays arbitrations are taking too long. So there is a lot of critique in this regard, and today we will then talk about some mechanisms that exist to try to get costs down and save time. So maybe Laura, you could start talking about some surveys that have been conducted regarding the satisfaction of the users of arbitration.
Yes, thank you. So we hear a lot, as Luis says, about costs and saving time and costs in arbitration. And the trend, I would say, over the past several years has been that it takes too long and it costs too much. And so a survey as far back as 2010 of Corporate Counsel International Arbitration Group found that 100% of participants found just that. It costs too much and it takes too long. And then more recently, a 2018 Queen Mary survey found that of the worst characteristics of arbitration, cost was number one. 67% of participants said that, and then speed ranked fourth, and lack of insight into arbitrators' efficiency ranked fifth. So this is really one of the biggest critiques of international arbitration, and increasingly so. Luckily, however, we see that arbitration is built upon the concept of a party autonomy. And most arbitration rules actually enshrine that concept of controlling time and cost into their rules, either explicitly as a mandate for the tribunal or as a guideline for the tribunal. So we will talk today about some of the ways that practitioners can harness those tools and really live up to their obligations to take advantage of the tools available to them to try to ensure a more efficient international arbitration proceeding.
So when we talk about saving costs and time in arbitration, obviously we have to discuss what are the costs in a international arbitration. So basically we have two broad categories of costs. We have the costs of the arbitration, costs of the arbitrators, and the cost of the institution. So we have the filing fees, we have the administrative fees, and we have the legal costs, the so-called legal costs. We're talking about attorney fees, experts, document production, interpreters, translators, and other costs in connection therewith. So how this plays out in international arbitration in terms of recovery of costs? We basically have these two categories. The cost of arbitration is generally awarded in full, unless, of course, the arbitration clause provides otherwise. But the legal costs, on the other hand, it works a little bit different, because although generally the institutions, they have broad rules regarding recovery of reasonable attorney fees, there is a lot of discussion when it comes to a judgment of arbitration of what would be reasonable. Should the party be reimbursed of all the attorney fees? Sometimes we have awards just granting the claims partially. So we could have a lot of discussions in this regard. So it is recommended for the parties from sometimes from the outset, when the parties are drafting the arbitration agreement. It is sort of difficult to predict, because you don't know from the outset, obviously, because you don't have still a dispute, whether you will be in an arbitration that you have more chances to win than to lose. So what we see in most cases is the parties having a provision in the arbitration clause that, for instance, the costs will be reimbursed in full for the losing party, but the attorney fees, sometimes the parties, they have the approach of establishing that each party will bear its own attorney's fees. And in Brazil, we have something else called, as you know, sucumbência, which is obviously generally applied only for judicial cases, but we have some scholars and we have some arbitrators advocating that this concept would also apply to arbitrations. So when you have in an international arbitration, if you have a US client, for instance, litigating in Brazil in an arbitration involving Brazilian arbitrators, this is something that in the course of the proceeding, in order to save costs and not have the risk of having a sucumbência, for instance, awarded to the parties to agree that no sucumbência would be possible to be granted. This is something really particular to the Brazilian market. I'm pretty sure that you don't have that in the US, right, Laura? So why wouldn't you comment on a little bit about how you see generally how cost allocation works in international arbitration?
Sure. Yeah. So as you mentioned, most institutional rules give arbitrators broad discretion to award costs and determine which costs are appropriate. And usually, absent any provision in an arbitration agreement that says how the cost should be awarded, arbitrators generally will award costs proportionally based on the relative success of each party's claims. So this is something that you may want to consider when you're drafting an arbitration agreement. Is a loser pays principle likely to benefit you, or would it be better to provide that both sides will bear their own costs in any international arbitration proceeding? It can be really difficult to determine that at the outset of a contract, but sometimes parties are aware that they're more likely to be on the receiving end, and want to avoid that from the outset. So just something to consider when drafting the arbitration clause at the outset. Applicable arbitration rules may also consider, in addition to the relative success, so just did you win or not on your particular claims, they may also allow considerations of parties' conduct during the arbitration. And so this is another thing to be aware of as you're conducting your case. If you're faced with an opposing party that's adopting what we call guerrilla tactics, so they may be trying to delay the arbitration or oppose any type of document discovery or taking unreasonable positions that prolong the case and add more time and costs. These are things that you can point out throughout the case to lay the groundwork for a costs award in your favor, or to potentially offset partially an adverse cost award against you. So during the case, you want to be constantly pointing out to the arbitrators and tracking and reserving rights on costs awards with regard to any improper delay tactics that might be used by opposing counsel, so that at the end of the case, you can make that case very strongly and hopefully with some numbers in there as to how this party's conduct added more time and costs to the case. And I think Luis, right, that's also allowable under the Brazilian system. Is that right?
Yeah. The bad faith, what we call bad faith litigation, we have a specific provision in the Brazilian Arbitration Act in this regard. Although we do have the provision, but we rarely see that in arbitrations. The arbitrators, they are usually more concerned something really severe has to happen in order to award some sort of a compensation for bad faith litigation. So this is not something that we see much in Brazilian arbitrations. So going through how to save time and costs, one way to do that, which is really important, is the arbitrator selection. Because too often parties and lawyers, they sort of underestimate the impact of the arbitrator selection on time and costs. They usually have the tendency to appoint the same stars, the same high profile arbitrators, but as we know, they can be busy, and also some of them are not really used to the use of technology, which can somehow cause some delay in the proceedings. So choosing an arbitrator, a seasoned one, that does not have the time to deal properly with the matter, can also be a route to delay the proceedings and cause excessive costs. And this is something that, for instance, in Brazil, we see a lot. The arbitration community is not that big. So we as lawyers, and I'm criticizing myself here, we have the tendency to choose the same arbitrator. So when you have a dispute and you are representing, for instance, the claimant, and you want the case to move forward quickly, considering thinking outside the box, considering appointing a more up-and-coming arbitrator who might have some more time to be more devoted to the case. Maybe this will cause the case to evolve, to develop faster. Maybe this arbitrator will have more sense of the use of technology. This is something that can play out really good in terms of saving cost and time in an arbitration. Obviously, a party is only allowed to appoint one arbitrator, but we also know that under a practice, when the other party appoints the other arbitrator and then they appoint the chair, there are ways to have an agreement with the other party to sort of have and the appointed arbitrators to sort of have a list choose the chair of the arbitral tribunal, which is also a very important selection that the parties should think about, because in the end of the day, he sort of will conduct the proceeding. So as much efficient and more proactive that he is or she is, the case will move forward in a more fast way. So this is something also to consider. So another thing to consider is whether there is really a need of 3 arbitrators. We do know that there are some arbitrations involving amounts not too high. So this is something that when you're drafting the arbitration clause, if there is, if the agreement is not an agreement involving really high amounts, maybe, or even if it is, you can sort of establish a threshold as to whether if a dispute is around X millions, the arbitration will be only with the participation of 1 arbitrator, and above certain amount with 3 arbitrators. So this is something that really can save costs, because one of the costs of the arbitration, as we mentioned, and a significant cost of the arbitration is the arbitrator's fees. So this is also something that you should consider. And Laura, I'm not sure whether in arbitrations that you have worked on, whether in the US or involving other countries, if there is also a trend to appoint the same arbitrators every time. So I would like
definitely. There's definitely a club mentality, I would say, in international arbitration in the US and everywhere else, it seems. And so some of the things that Claudia was mentioning about considering women, considering younger practitioners, these are things to take into account in your case, and in particular with regard to discovery, which we'll talk about in a little bit. You want to make sure if you're going to have discovery in your case, you have an arbitrator in the chair that's going to know how to deal with that. And so you might want to consider someone who is going to have the experience and is going to understand the technology that's involved and be receptive and willing to engage in considering discovery disputes, which arbitrators sort of notoriously hate to get involved in. So something to think about.
Yeah. So another way to try to save costs and time is through the bifurcation of seeking a partial award during the course of the proceeding. So this is something that has become really usual in arbitrations, either domestic and international arbitrations. We do have, in most of the rules of the arbitral institutions, we do have provisions in this regard, allowing for partial awards, allowing for bifurcation. And more recently, also the Brazilian Arbitration Act, there was a provision including in the Brazilian Arbitration Act in this regard, allowing arbitrators to enter partial awards. And this is something that really could save time and costs, because sometimes you have, for instance, questions, issues to be decided regarding jurisdiction, preliminary issues. It wouldn't obviously make a sense to decide on an issue on jurisdiction, that is, as to whether the arbitral tribunal would have jurisdiction to hear the case after a entire proceeding. So obviously, this is something that would have to be decided from the early stage of the arbitration. Also, we have many occasions in which you have in an arbitration several claims made by claimant, and some of them, for instance, after the arbitration hearing, they are ready for judgment, and some have not, and some are not. Some could, for instance, depend on expert examination to take place. So this is when bifurcation and partial awards are particularly important, because they could save time. Sometimes we see when a partial award is entered, for instance, in a case that you're discussing which party has a certain right, and there is a declaratory judgment, but we still have to computate the damages in a liquidation phase, or we need an expert examination. So this is typically a case that sometimes a partial award could lead the parties to settling. They will not want to go over the all the expert phase to expend more money in expert examinations, in hiring their own private expert assistants, and also to pay more arbitration costs and fees for the arbitrators. So this is something that a party must really think about, depending on what is being discussed in the arbitration, and all the set of rules of the arbitral institutions, they allow for that. So this is something that we strongly recommend that be made. Right, Laura?
Yeah, and just to quickly add on to that, I think, they're particularly useful where there's a possibility of early dispositive relief. So sometimes called summary disposition, either as the whole case or as to a significant number of issues or issues that will significantly narrow the amount in dispute. And arbitrators tend to be reluctant to use this absent agreement of the parties, but there are certain cases where, if the facts are not in dispute on the issue, the arbitrators will acknowledge that this is likely to increase the efficiency of the case. So a perfect example of that is statute of limitations or other procedural barriers to the case. I had a case early in my career where we ended up doing an early partial award submission, and we ended up eliminating 90% of over 90% of the damages in dispute on that basis. It also has the added effect of helping to focus the tribunal very quickly on some of the key aspects and the strongest aspects of your case. So that can actually be quite helpful to you to get the tribunal really thinking about the case and what are the real levers and drivers here that affect the parties' dispute, so that when you head into a discovery phase, let's say, that might occur afterwards, the tribunal will have a better understanding of the case and be more receptive to what is actually relevant and material to the case.
Yeah, sure. So another way that we thought about discussing here with you to save costs and time is limitation of discovery. And since discovery is a concept that we do not have in Brazil, such as in the US, obviously we have the evidentiary phase in Brazil as well, production of documents, so on and so forth, but not as broad as we have in the US. And there is a trend, and this I asked Laura to comment on, because if you have an arbitration, international arbitration with, let's say, Brazilian lawyers at one side and a Brazilian company and a US company on the other side, there would be the US party would be more inclined maybe to sort of try to apply something in the arbitration proceeding more similar to what would be the discovery in the US. So it is really important for the parties to try to limit what would be possible in terms of exchange of documents, request for production of documents. So Laura, could you please comment on a little bit on this, because I think your input would be really nice for everyone, especially from the Brazilian audience.
Yeah, of course. While the US gets blamed for a lot of this, I will say that even civil law practitioners increasingly have very broad requests in international arbitration. So this is the reality, and I think parties need to accept this is the reality, that in an international case, especially with sophisticated parties, you're going to probably have to face some discovery. And so, the important thing to recognize is how, which tools can you use to try to control and limit the extent of that discovery in an arbitration case. And we could talk about this all day. I'll just focus in on a few. One is obviously in the arbitration clause. Usually this is silent on discovery issues, but you might want to consider adopting the IBA rules on the obtaining of evidence in international arbitration. This is a set of rules that's very commonly adopted, and it allows parties to seek either only specific documents or a narrow and specific category of documents that has to be both relevant and also material to the outcome of the case. So that's an important set of guidelines, again, very commonly accepted in international arbitration, that allows the tribunal some tool to try to limit the scope of discovery. It also allows the parties to argue that a document request should be denied because it's too burdensome or it's overly broad. You might also consider in the arbitration clause prohibiting specific types of discovery, which are more common in the US or common law jurisdictions, such as interrogatories, which are written questions and answers, or depositions, which are basically the early questioning of a witness. Those are not very common in international arbitration, but something to consider in an arbitration clause. Once you're in the arbitration, however, there are a few key ways to try to control the discovery situation. The first is really using the opportunity of the first procedural conference or case management conference to start signaling to the tribunal, what are your expectations about discovery? And make sure that those expectations get enshrined to the extent possible into the first procedural order issued by the tribunal. So again, adopting the IBA rules, very typical. It's usually easier to get agreement on that at the beginning of the case. So make sure to get that, something like that in there. And require the use of a Redfern schedule. Again, this is very typical. It's 4 or 5 columns, which has one party's request, the basis for those requests, the opposing party's response to the request, and the tribunal's decision. My big tip on that is to make sure to include a time period for the parties to confer with one another before submitting that Redfern schedule to the tribunal. Sometimes this is missed, and I think it's a real problem. So you want to make sure you have a time period in which the parties can talk to one another, and include a separate reply column in the schedule where the parties' agreement or offers to narrow the scope of their request can be indicated to the tribunal. And then you want to set a reasonably short time frame for the discovery phase in the procedural timetable, because if the parties grant 6 months to produce documents, then, well, the expectation you're providing is that there's going to be significant discovery. So that's something to consider as well. A few kind of key tips for limiting discovery where you think it's going to happen. The first one is to start early. If discovery is likelihood, don't wait until a discovery phase to plan for it. Knowledge is power. You have to, it's really hard to argue about why discovery is onerous or to try to reach some reasonable agreement with the other side if you don't know and don't have a good handle on what documents are out there and what are the key risks are with those documents. So you want to look at the request for arbitration and think about what documents you need, but also what documents the other party is likely to ask for, and then have a frank discussion with your client and with their IT personnel about the key sources of data that still exist. Who are the key people? Is there a database? Is there a shared drive? And then if possible, try to collect all that data from the client early on. I know that sounds onerous to a lot of people, but there's a cost in doing that, but it's far less than the cost of doing a linear document review. And that's really what you want to avoid. So try to collect the documents, because if you do collect them, it allows you to understand the extent of the documents and puts you in a far better position to make arguments about limiting the scope of discovery in the Redfern schedule process before the tribunal. So for example, at Baker McKenzie, we have the ability to go in-house, to go out and collect data from clients and process it very quickly. Other firms might need to engage an outside vendor to do that, but I think it's well worth it if you're going to have to do it eventually anyway. The second tip is to be reasonable. That may sound strange coming from a US lawyer, but be reasonable. I think this is the single best way to limit the extent of discovery. Surprisingly, not technology, but people. Offer a reasonable opportunity to your reasonable alternative to your opposing party. And if they refuse, take it to the tribunal. When you receive the read firm schedule request of the other party, you got to think about what you can offer to them that's going to give them the crux of what they need, but avoid this broader fishing expedition, for example, into everyone's emails. Are there board minutes and presentations that can be offered rather than all of the emails? Are there certain financial reports that can be offered rather than a search for a number of individuals' data? Is there a particular time period? You know, these are all things that you can think about and try to offer, because the reality is tribunals hate dealing with discovery disputes. They might look at a request and think it's too broad, but at the same time, they also think the party kind of really needs that information. So you want to avoid an all or nothing result. And my experience is that usually if you offer a reasonable intermediate solution, tribunals will very often welcome that. And then you'll be left with discovery, but discovery that's manageable. And finally, you want to be specific in your objections. So it's really important to stress and explain to the tribunal, which probably isn't that familiar with the case yet, why a request is not material to the outcome of the case. You have to spell it out. And then use the technology to your advantage. So explain the burdensome nature of the request. Don't just say it's burdensome. If you already have the documents collected, you can credibly tell the tribunal exactly how much time and money is going to have to be expended if they grant a particular request. You can explain to the tribunal, I'm going to have to search for all the emails from these 10 people over this particular time period for these particular search terms. And I'm going to get, when I do that, I get this many hits. And that's going to, at a typical review rate, take 6 weeks and $500,000 to review. So these are ways that you can be really specific and really bring it home for the tribunal that this is going to derail the case. It's much more convincing than just saying it's burdensome. And finally, if we have time, I can talk a little bit about technology that you would use. So at Baker McKenzie, we have one of the most common e-discovery platforms, which is called Relativity. And this allows you, once you have the documents, to code them for specific particular issues or document requests, to group documents together to allow this to all happen more quickly, and to provide significant analytics on the documents. So you can sort of map, have tools to map different types of concepts together and quickly identify groups of the most relevant documents. You can also use it to artificial intelligence components of the technology to try to make any document review you do happen much more quickly and effectively. So for example, as individuals are coding documents for a particular issue, Relativity can continuously learn which documents are the most relevant for that issue and constantly push those relevant documents up to the top of the queue so that you reduce overall the number of irrelevant documents that are ultimately going to have to be reviewed. And this technology is just growing by leaps and bounds every year. There's a ton of disruptor technologies out there. And so this is something, you really want to consider if you're in-house, consider which technology your law firm is using and whether they have the resources at their disposal to take advantage of taking some of the guesswork and the human element out of this process. And then finally, you want to think about using search terms to ensure reasonable limitations. So if you get that very burdensome order to produce documents, you might consider at that point engaging with the other party on a set of reasonable search terms to try to limit that scope. And again, this is going to limit what you have to do, but it's also going to protect you from an argument later on that every single document under the sun was not produced. So the use of search terms is really important and is increasingly common. So think about that as well. Outside of the e-discovery realm, there are also other technology tools that are quite interesting, I think. My favorite one right now is machine translation. And this is, we're all familiar, I think, with Google Translate. So if you have an international counsel team, as Joachim and I know very well, it can be very difficult when you have a lot of documents and they're half in Portuguese and half in English, for example. And so one way to vastly cut down on a huge expense in that type of arbitration is the delay and the cost associated with translating documents. Most of the time in international arbitration, we don't need certified official translations. We just need convenience translations. And this type of technology allows you to take thousands and thousands of documents and quickly convert them to another, quickly translate them in a matter of minutes, days. You can get thousands of documents back in a couple days. And then you can upload those or link them in your document review platform, like Relativity, to the original document, so that your whole council team, if you're working internationally, can see both versions of the document and can just work a lot more effectively. So these are things that you want to think about. You know, what technology tools are out there, and am I using the latest ones to try to avoid some of these big bottlenecks in terms of time and costs?
Mm-hmm.
Okay, I think if we are about to, you are right.
That's what we had to talk about, some tips in saving costs and time in arbitration. So we thank you all.
It's a big thank you, Luis. Thank you, Laura. Juliana, want to close?
Yes, Joaquin, thank you. I think it was great to hear all the different experience we had. Professor George Lee with a great experience in Singapore. We had Claudia also talking about the gender agenda and why and the reasons for the importance of that. And Claudia said a phrase that was very significant to me, that I'm also a gender ambassador, as you all know, here in Trent Rossi in Brazil. And I think Claudia summarized it very well. It's important not only for the women, but for all the community, for all the families. So that caught my attention. E aqui, passando para o português, só para agradecer ao Dr. Kazuo Watanabe, foi uma honra tê-lo aqui conosco hoje. Dr. Kazuo, acho que é sempre revigorante ouvi-lo falar das questões de mediação, de como o senhor é um entusiasta das medidas adequadas de resolução de conflitos, né? Não são alternativas, são as mais adequadas. Então, eu agradeço muito sua participação. Foi um prazer tê-la aqui conosco, ter o seu tempo aqui, como o Joaquim falou, que é a coisa mais preciosa, doando o seu tempo aqui para nós, para o nosso público. Agradeço, I thank Laura, Zimmerman, and Luis for the excellent presentation, saving time and costs. It was great to hear you. Thank you, Laura, especially Laura. She's in the US and kindly joined us today, so thank you very much. I think it was a pleasure for our audience, for me at least, having the opportunity to be here to hear everything that was said. So I just want to thank you all the speakers again. Thank you, the participants. And we are, of course, open if any of the participants have any questions. Unfortunately, I think we are a little bit late, so we have to close. But the participants have our contacts. We'll be more than glad to answer questions. Claudia, unfortunately, had another meeting, so she left us and thanked all the participants, thanked for the opportunity. And in fact, we have to thank Claudia for that, of course. So I think that's what I had to say, Joaquin. If you want to say something to close, please feel free.
Just thank you. Obrigado. It's been late for George. Thank you for holding. Professor Kazuo, um imenso prazer, sempre esclarecendo, né? Bom ver a luta do escritório pela igualdade mostrada aí pela Cláudia e pensar fora da caixa, como o Luiz e a Laura mostraram para a gente. Então, agradecendo a todo mundo, até o nosso próximo evento e muito obrigado por vocês ficarem até o final.
Obrigada, um abraço a todos. Tchau. Thank you, George. Thank you, Laura.